Let's bring in now News 13 legal analyst Mark NeJame, who is standing by now for more analysis. And Mark, you said yesterday that was not the best day for the defense. Would you say the defense has rebounded today, and why?
Oh, it's not a full rebound, but they're inching their way upward. You know, they're doing a much better job. They're getting out the points the way that one side is supposed to get them out. But I wanted to comment about one thing about this HOA individual who's on the stand. You'll notice that he keeps on indicating they are separate from the neighborhood watch is completely separate. Remember, the Homeowners Association has been civilly sued by Trayvon Martin's family, and there is an undisclosed judgment that's been sealed. So he's very much guarding his other interests by bringing that out repeatedly. So that's not going to come into court, but you'll see how that in some ways can bias or impact or affect a witness's statements. Remember, not everything that happens always comes out in court. Only what's admissible by the rules of evidence is permitted in court. And what we hear here is an individual who clearly is saying certain things because I would imagine in part he doesn't want it to seep into another liability for another entity.
That's a good point, because you have to say O'Brien's testimony did feel a little guarded, as if he was being very careful about how he was answering questions, right?
Yeah, that's what I saw as well. And so,
yeah.
And remember, word is out. We don't know the exact amount, but it was over $1 million. And that's the rumor on the street. Who knows how true that is, but that the Homeowners Association, in fact, settled with Trayvon Martin's family for this. I don't know if it was the Homeowners Association or the Neighborhood Watch, but I think it was the Homeowners Association. So I think that, you know, that can always impact something. You want to make sure that if you're representing an entity that you're saying things the correct way and the honest way, but nevertheless not opening up a door for some other future civil liability.
All right, Mark, let's talk a little bit more about the testimony from Wendy Dorval. We heard a quick soundbite from her. She is the person who is kind of control of the Neighborhood Watch and kind of controls with the Sanford Police Department as well as the community. There's a lot of focus about that one statement in that 911 call that we have played over and over again, where the 911 non-emergency dispatch officer says, you know, are you following the suspect? And he says yes. And he says, okay, we don't need you to do that. Do you think the defense has done a good enough job, or the prosecution's done a good enough job of trying to set up whether or not what he did was wrong and or right? Because it seems like that seems to be the focus of a lot of contention.
Well, they're going to spin it that helps them. Look, she says you don't need to do that, but we know that's the policy. But on the other hand, she says, what's he doing? And how are you going to know what he's doing unless you're following? And then it's compounded by the witness statements on the stand of, you know, you're allowed to watch them, but not to get too close. Well, how do you watch somebody without following them? And if you're not allowed to follow them, then how do you answer a question about where they are? And so, and if you're supposed to turn it over to law enforcement, why did you not do so? So these are not so simple, and that's why when we see extreme positions on both sides, we have to say, whoa, slow down everybody, let's really analyze what was said and what happened, because we have the advantage of having a year and a few months worth of analysis and being able to break all this down. Remember, when all these things are happening, they don't, one, anticipate this, although in many ways they should, and two, it happens in split seconds. So, you know, people don't have the luxury of the analysis and the breakdown and the review that we do now. So the issue, though, is if there is confusion about what was said, and if the state can't establish that it was clearly one way, that sides to the defense. Why is that? Because wherever there's confusion, wherever there's ambiguity, there lies doubt. And when there is reasonable doubt in a case, that legally is supposed to and appropriately sides with the defense. So the state is the one who has the real burden here, as they do throughout the trial, of really honing down on that issue that George Zimmerman, his actions were an aberration from what was supposed to happen. And it's up to the defense to be able to say, it was not as clear as that it was subject to interpretation, and if in fact they're asking a subsequent question as to where is that person now, that would suggest that he's supposed to follow but at a safe distance. So the state really needs to hone down on this point, because if they leave any loose ends, therein lies ambiguity, and therein lies reasonable doubt as a possibility, as a great possibility if they don't focus on that point.
But I'll tell you what, Mark, I think we're going to hear a lot more about that for sure. So please stand by for that. Right now, we want to go back inside of the courtroom right now here at the Seminole County Criminal Justice Center, where they are now welcoming in the jury back in for more testimony in day 2 of testimony here.